full court of the Federal Court of Australia is now in session.
The court this morning, the court made orders prohibiting the recording of the hearing, in particular Order 2 and the notation as to contempt in Order 3. That order, that is Order 2, is revoked for the purpose of making these orders and for what follows. The court is in a position to make orders which are unanimous. The court is not in a position to deliver reasons today, but will make every attempt to deliver written reasons as soon as possible in the coming days. Given the interest and coverage of this dispute between Mr. Djokovic and the ministers of the executive government, and the interest and coverage in different parts of the world, including Mr. Djokovic's home country of Serbia, the court considers it appropriate to make clear a number of matters about the process that has taken place. First, this is not an appeal against the decision of the executive government. It is an application to the court as a separate arm of government, being the Commonwealth Judicial Branch, to review the decision of a member of the executive, the minister, for the lawfulness or legality of the decision on the three grounds put forward. These grounds focus on whether the decision was, for different reasons, irrational or legally unreasonable. It is no part of the function of the court to decide upon the merits or wisdom of the decision. The orders of the court are: 1, the amended application be dismissed with costs, such costs to be agreed or failing agreement assessed. 2, reasons to be published at a later date. Those are the orders of the court. The court notes, this is not part of the orders, notes that some orders were made by the Federal Circuit and Family Court of Australia earlier. The court does not consider and is not aware of the need for any further orders, but the court will adjourn for up to 30 minutes to allow the parties to consider whether any further order is necessary. The court does not suggest that it is. If either party thinks that some further order is necessary, there is to be a joint communication from the solicitors of both sides to my chambers, that is the chambers of the Chief Justice, as soon as possible. If no further order is required, the court would be grateful for notice of that to my chambers as soon as possible. It goes without saying, if counsel can tell the court now that no further order is necessary, I invite counsel to do so. Mr. Wood or Mr. Holden? Are you able to indicate now, or would you prefer some time?
Your Honour, I think the answer is no, but if we have the opportunity for brief reflection, we'd take that.
Very well. Well, the court will then adjourn, as I've indicated, and the court will be grateful for that communication as soon as possible, Mr. Wood. Mr. Wood, rather than do this on the fly, I think we'll adjourn, and if you communicate or the solicitors communicate in the way I've identified, if there is any need for any orders. Thank you. Court will adjourn.
This court is now adjourned.